My name is Pigman Wen. In this case, Burum challenged the European Community Regulation number 2136/89, which restricted the use of the trade description sardines for Peruvian products. According to the relevant Codex Alimentarius standards, Sardinus saga can be traded as sardine, but the EU EC regulation constitutes an unjustifiable barrier to trade. Burum argued that this regulation violates Article 2 and 12 of the TBT Agreement and Article 11.1 of GATT 1994. Additionally, Burum claimed that the regulation was inconsistent with the principle of non-discrimination under Article 1 and 3 of GATT 1994. So today we will provide a comprehensive analysis of this case, covering its facts, issues, rules, regulation, application, and conclusion. Thank you.
Hi, my name is Binu Minduli Devanga Gunaratnan. The disputes began on the 20th of March 2001 when Peru requested consultations with the European communities regarding Regulation number 2136/89, which restricted the use of the term sardines for Peruvian products. The DSB, also known as the Dispute Settlement Body, established a panel on the 24th of July 2001, and the panel was composed on the 11th of September 2001. The panel issued its report on the 29th of May 2002, and the DSB adopted both the panel and the appellate body reports on the 28th of October 2002. The parties involved were Peru as the complainant, the European communities as the respondent, and the third parties including Canada, Chile, Colombia, Ecuador, Venezuela, and United States.
Hello, this is Ilma Rizaniki. Today I am going to talk about the issues. The main issues in the dispute were first, whether the European Communities Regulation number 2136 by 89 was consistent with Article 2.4 of the TBT Agreement. Article 2.4 requires that technical regulation should be based on relevant international standards. 2. Whether the regulation violated Article 11, 1, 1 and 3 of GATT 1994. Specifically, Article 11.1 prohibits quantitative restriction on imports and exports. Article 1 enforces the most favored nation (MFN) principle. Article 3 mandates national treatment for imported goods. Thank you.
Hi, my name is Kwaji Hosseini, and I'm going to be talking about the rules. And this part is divided into two: the technical barriers to trade and the GATT. And under the technical barriers to trade agreement, Article 2.4 requires that technical regulations should be based on relevant international standards, such as the Codex Stand 94 for the trade description of sardines. Codex Stand 94 allows species Sardinops sagax to be marketed as sardines as we all know it. Additionally, Article 12 of the TBT Agreement provides special and differential treatment for developing countries, ensuring they are not unfairly impacted by technical regulations. For the second part of the rules, we're talking about the GATT 1994. In GATT 1994, Article 11 prohibits quantitative restrictions, which means that regulations cannot limit the quantity of goods imported or exported. Article 1 enforces the MFN principle, ensuring that all WTO members receive equal trading conditions. Article 3 mandates that imported products be treated no less favorably than domestic products regarding internal regulations and taxations.
Hi, my name is Rachel Jimenez Santos. For the application, the panel found that the EC regulation was inconsistent with Article 2.4 of the TBD agreement because it did not use Codex TAN 94 as the basis for its technical regulations. The regulation also violated GATT 1994 Articles 11.1, 1, and 3 by imposing quantitative restrictions and discriminatory treatment against Peruvian sardines. The appellate body upheld the panel's findings on these points but reversed the burden of proof, determining that it was Peru's responsibility to show that Codex TAN 94 was an effective and appropriate means for fulfilling the legitimate objectives of the EC regulation. The appellate body agreed that the EC regulation was discriminatory, thus violating GATT 1994 principles.
My name is Heng Chiu Chen. In conclusion, on 25th July 2003, the European Communities and Bureau reached a mutually agreed solution, resolving the dispute on international standard for the trade description of sardines. This case highlights the importance of adhering to the international standard like Codex 94 and demonstrate the role of WTO in the mediating trade disputes and ensuring that countries comply with international trade agreements. By reaching a mutually agreed solution, the EU and Peru showed a commitment to resolving trade issues in a manner consistent with WTO principles. This case also underscored the necessity for clear, consistent, and fair applications of trade rules to prevent unnecessary barriers and promote equitable trade practices among WTO members. The mutual agreement solution shows that on 25th July 2003, the European Communities and Bureau informed the BSD that they had reached a mutual agreed solution pursuant to Article 3.6 of the SU. That's all for our presentation. Thank you.